might have noticed that the sheet also includes a course number if you want to report those yourself. People ask generally how soon can you get these numbers into the state bar. We usually enter them all by the next week, so it's very prompt. But if you want to do it yourself, please find the course number, which is printed outside on the side of the sheet, or come talk to me and I'll give that to you. Tomorrow we will be in room number 3. This is room number 1. I'm sure if you forget that I told you that, you'll figure out what to do. But just know that we're going to be in a different room. So let's start. We're going to be scrutinizing controlled substance lab results. Moderating this discussion is going to be Nick Hughes with the Public Defender's Office, and joining him is Keith Larson of the Larson Law Firm. And from the Houston Forensic Science Center, we have Dr. Peter Stout and James Miller. Welcome.
Thank you. Well, Keith, I'll let you start because you kind of led us to this whole thing. Can you tell us a little bit about the land case?
Sure. I'm just a line attorney. I do appointments. I get an appointment in the 351st District Court in July 2013. Possession case, methamphetamine, 1 to 4 grams, but my client's habitual. And the facts of the case: traffic stop, failed to signal, baggie found on the driver's side door, inventory search. My guy doesn't have a license. The passenger has a suspended license. My guy makes a statement: it's not meth, it's bath salts. So the first thing I do, and he was habitual, but his last case was a murder case, which he got 9 years for. So somebody did some good lawyering, but the flip side is that I could see where this 2 to 10 case was going pretty quickly. So the first thing I did is I talked to him, and he's like, it's bath salts, it's bath salts. I go back to my office. Will bath salts make a field test positive for methamphetamine? And pretty much yes, it will. Because bath salts is an amalgamation of whoever is making this stuff throw together. And back in that time, in 2013, most of it was coming from China. And they would change the chemical composition by 1 carbon atom here or there so that it would be legal to import to the United States. And those of you who dealt with bath salts at all, it's just a chemical mess, basically. It's whatever they can get to import and sell into the United States. So then I immediately go to the client a couple days later, and I meet him at the jail, and it was basically a come to Jesus meeting, because I knew that they were going to hold him to the 25 to life as soon as they indicted him because of the prior murder, which he got 9 for. And I said, hey, if it's dope at all, and you think it is, you need to make a deal quick because they're going to hurt you. And he's like, it's not dope, it's bath salts. And I said, bath salts, A, are A, illegal, and B, would make the field test come up. And he's like, it's not, it's not, it's not. So we go along, and I go back to court again, and in the court at that time, the prosecutor, let's just say most of the recommendations and the deals in that court were about 20 to 30% higher than I was getting in other courts, just as a general rule. And in my experience, when I would bring up something that might be mitigating, that might be something we can negotiate a little better deal, they were taking it as a personal challenge. Oh yeah, watch this. Rather than deal with the issue, they would fix the issue. And that happens in some courts. You know the prosecutors that do it and everything, and it's just something I can deal with. But as far as trying to protect my client at that time, I could see the writing on the wall. A couple months later, the indictment comes down, or the lab comes back, and they indict it, possession of cocaine. So it's like, okay, he was right. It wasn't methamphetamine, but it was cocaine. So then I'm doing more research into the field tests and everything. How would this come back? And the description in the offense report was a crystalline substance. Okay, it wasn't like a white powder. It wasn't like a crack rock, a yellowish white rock, or anything like that. So it was like, okay, comes back as cocaine. And you all know the one-liners. You've seen them. You get from the lab. Contains cocaine. Boom. Most of us think, well, that's, if you've read the case law, adulterants, dilutants, and everything else. If you've been around, you know most of the substances in Harris County are cut with stuff, whether it be baking soda or whatever. But if you get that contains cocaine, you're pretty well screwed. And that's, I kind of went back to my client, and he's like, it wasn't cocaine, it was bath salts. And I'm trying to figure out what can I do, because quickly it went from maybe 5 years to he's habitual, we want 25, and the case gets reset, and and eventually they're just like, we want a double-digit counter. And my guy is like, hey, I got 9 on a murder. I'm not taking double digits on a 1 to 4 case. The flip side is that if we go, this is as far as the case law and a traffic stop and everything else. I talked to him, I talked to the witness and everything. This was going to be about a 15-minute case. Put the cop up, fail to signal, and especially with the judge in the 351st, he knows the law, and he'll let you know every chance that he knows the law. So as far as like an inventory stop or something like that, it was just going to be a steamroller. So at this point, I am screwed, and I figure my client's in worse shape than I am, and I'm trying to figure out what to do, because I'm looking up inventory search, I'm looking up everything. And then actually they did a CLE talking about forensic science, and there's a 2009 report on forensic science and how you really need to go back and look, because a lot of times what we take for granted, especially as an attorney, of this is the science and it just is, well, it's not always, basically. I mean, the guy that they got for the Madrid train bombing, it was a lawyer out in Oregon, and yeah, and they, 4 analysts with the FBI said, yeah, that's the guy. And they arrested this guy, and I mean, he ended up getting about $6 million because they finally realized it was groupthink, and because the supervisor at the fingerprint lab for the FBI said, yeah, it matches. And finally, the Madrid police said, we got some Algerian that this matches, and he happens to be a known terrorist. And they finally figured out they got the wrong guy. But that's fingerprints. Now, how many of you have heard him testify? Have you ever had somebody with the same fingerprints? No, I never have. And the judges bless off, and the jury believes a fingerprint because it's been around 100 years, and your client's gone, whether it's their priors or a robbery or whatever with latent prints. So I was looking at it in my case and figuring, I've got to find some reasonable doubt. And plus, my client is pretty adamant. It's not cocaine. It's not meth. And we've all heard the bullshit from our clients. And when you do this long enough, you get kind of jaded because you think, I'm just getting the jive. But I'm looking at this case, and this guy, I mean, he's going to get pounded. And he's been around, so he knows it. And he's still going, So I decided, looking at it, and when I was a prosecutor, I went to the lab to do a little show and tell one time. And they were very nice, and they showed us everything, and they showed us the lab reports and everything. And looking through the forensic science report from the DOJ in 2009, there are bench notes, lab notes, whatever, that a laboratory will do when they're working on a controlled substance. And I'm like, I got nothing at this point. My guy is going to get pounded. I don't really have reasonable doubt. So I called up Mr. Miller and said, hey, can I come by and take a look at the lab notes? And the lab has always bent over backwards, whether when I was a prosecutor or as a defense attorney. Sure, come on down. In this case, he said, get an order from the judge, fax it down, make some arrangements. And so that's what I did. I just made up a quick order. Judge signed it. And actually, I picked a visiting judge to do it because I just really didn't want the court staff or the court to kind of snap to what I was doing because of what I said earlier. I kind of felt like if the prosecutor knew where I was going, they would circle the wagons and stop what I was doing. So anyway, I went down and I met with Ms. Rodriguez, who wasn't the person who did the lab, but it was the supervisor. She was very nice, and what they gave me was a disc, and it turns out to be a bunch of pages. And what was on that, evidence submitted a Ziploc bag with a crystal substance. And then there's various presumptive tests that they do, and they're, I'm going to say, since they're in a laboratory condition, it's more than a field test would be, because it's not some cop doing it on the trunk of his car or whatnot. You're doing it in a lab. But they're presumptive tests. Negative, 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 negative. First run on a gas chromatograph, negative. Well, while I still wasn't jumping up and down, I had some reasonable doubt at that point, okay? But what scared me more, and I was talking with Ms. Rodriguez, I said, you know, these negatives, that's Brady material. But she's a lab tech. I mean, she's a scientist. She's not the lawyer. But I said, this is Brady. This should be turned over. And I wasn't trying to be, I wasn't confrontational. I was just talking with her, and she was very nice, and she'd explain anything that I asked. And I said, how often does this happen? And she said, more often than you would think. And kind of the light bulb went on that, oh shit, there's some Brady out here. Or there may be people who have things like this that should have been turned over to the defense. Now, the thing is, she's just a lab tech. She's not the prosecutor or whatever. When I went back to the prosecutor, I got kind of what I expected. Look at the one-liner. It's the one-liner. That's all they want. That's all they need to get the conviction. And I said,
if I may, are you providing, or are you provided any sort of Brady training at the laboratory? Is there any effort by the DA's office or by anybody to say you need to look for these sort of issues and bring them up to us?
Well, the first response I would have is that the prosecutors themselves don't have the case files either. They don't ask for the case files. So that may go to your point about Brady. If they don't ask for it, they don't have it. That may be one of the reasons why they don't ask for it. But typically, all they want is that summary report. So as far as providing you what they have in that case, they are.
Right.
But the main point that we want to make is you can get that material from us. Don't rely on the prosecutor to provide it to you. Contact us and get the information yourself. If the prosecutor wants it, then they can ask for it. But don't rely on them to provide something to you that they don't have.
Right. Well, I mean, unfortunately, the way that the Brady has come down, it's on the duty of the prosecutor, and it's the duty of even the laboratories who are conducting the sort of test. And I guess they just don't make it really clear. And there are two general categories. It could be one that it's exculpatory. It says you are not guilty or you may not be guilty. And the other category is even broader, and it's mitigation. And I think that's really important in cases like this because it was an over a gram case, but we were talking about a very, very small amount of cocaine that was detected, a low concentration. And when you're getting into punishment, it could be an issue that's important. So I think it's an issue that we're all going to need to keep looking at down the road. And it just, who has the duty? It's probably going to be on the state, but I think still your point of getting the information is correct.
And one of the things that we are developing is a mechanism by which you don't just receive that one page.
Right.
You automatically receive attached to that one page that entire case file that Keith received. That way, whoever looks at that report will receive all of the information, whether it be the prosecution or whether it be the defense. You won't have to ask for it, but we have to get that mechanism in place within our electronic system.
Right.
The one that provides the one-page report, we have to be able to attach all of that other documentation at the same time, and that's what we're actively looking to do.
And just to kind of clarify, so the lab report, you'd say that's just the conclusion, right? It's not necessarily any of the work, it's not necessarily any of the details or observations. It's merely that conclusion. It's not the homework. It's not showing your work if it was a math problem.
That's exactly right.
No, sorry.
no. Anyway. So, at this point, I've got some reasonable doubt. And and I kind of was flipping a coin, whether or not, do I get my expert and make this a battle of the experts? Do I tip my hand or anything? And what I did do is I did mention to Mark Poachblow. I said, hey, I've got this case and the dope changed, and I think that they're not necessarily turning over what I think is Brady material. Now, in my case, I found it, okay, and it was available, so it's not like the prosecutor didn't turn it over, so. But I had a feeling, and I still have a feeling, that there are cases out there where there are cases like this where there are negative, for whatever reason. I mean, chemically now with bath salts and everything else, you're getting, I mean, I still get where there's crazy stuff that people will ingest. I mean, they will mix heroin and cocaine because it'll be a speedball, or they'll mix methamphetamine with something. But as far as with the lab reports and everything, I mean, they'll end up knowing, but necessarily as an attorney, do you always know what you're getting? In this case, what it brought up to me is that there may have been an issue with contamination, or there may not. I mean, I don't, to this day, I don't know, because who knows if you get something on the street, what's in it? Does your client even know, really, what they're getting?
If we could
Right.
talk about that a little bit, we were talking a little bit earlier about the instrumentation. If you could just give some idea of how sensitive, especially the GCMS machines, these gas chromatography,
Right.
mass spectrometry machines, how
Right.
sensitive are they?
The instruments that we use can detect a billionth of a gram. If you use your classic sweet and low packet, divide that up into a billion parts, and we can still identify it. So one of the things that Nick and I were talking about before we started the panel discussion is, as the instrumentation that we use becomes more sophisticated and produces reviewable data, the flip side of that is we're detecting even smaller and smaller and smaller amounts. Now, as a scientist, I detected cocaine. As far as the significance goes, that's up to the jury to determine, or the judge to determine, and from my understanding, from the prosecutors and from the defense to make that point. But if you ask me, did you detect cocaine? Yes, I did. And in a testimony situation, this is the other point I want to make. In a testimony situation, as an analyst, I am extremely limited in what I can say, right? I can't just go on and explain, well, I detected cocaine, but it was in such a small amount. There's going to be an objection from one side or the other as soon as I start narrating. So my suggestion also is not only get the case filed, but contact the lab and set up a pretrial conference like Keith did in that situation. Don't let the first time you talk to an analyst be when they're on the stand testifying, because more than likely, if you've never testified before, you don't understand what that's like. I may have 25 years experience, but as soon as I get on that stand and I'm testifying, the nausea comes up, the frustration comes up, the fear comes up. It's an experience unlike any that you have ever had. And when you are asking me questions, I may or may not be 100% cognizant of what you're asking me. And I'm answering the best I can, but I may not be interpreting from the way that the questions are phrased what it is you're trying to get across. But if we've had that conversation before the trial, in a calmer situation where we can just talk, then I will understand the points that you're trying to emphasize. And when we get into the courtroom, understanding the limitations that you have to ask your questions in a certain way, at least I'll know where you're going with that. And then hopefully I can answer appropriately to the question that you're trying to ask, and not be in that situation where I'm trying to answer your question as I understand it, but it's not at all what you're asking me. That can get into some confusing points during testimony. So that would be my recommendation. Get a hold of the case file, set up a pretrial conference if you don't understand what the file is saying, or if you have some questions, and let's have that conversation first before we get into the testimony situation.
And that should apply in pretty much any forensic situation.
Yes, yes, not just a drug case, but any forensic case. The center is open for all of the disciplines. We're here specifically talking about this as an example,
Right.
but you're absolutely right, Nick. It's not limited just to controlled substance cases. We have the same procedures in place for all of our testing.
And if you look out of some of the conversations we've been having around this, if you look at the bottom of report anybody to come ask for all of the case files. That's all you gotta do is ask us. There's an email on there to do that. So that's as much for controlled substance as it is for tox, as it is for firearms, as it is for labels. It's gonna take us some time, and as I keep digging into some of our legacy computer systems. So I've been with the center now for 8 months. Last 10 years I've been in the not-for-profit research sector. Before that I was director of a commercial laboratory. Before that I ran one of the Navy's drug screening laboratories. So I'm a toxicologist by training. But it's gonna take us some time to build the systems to be able to do what I'd like to see. Of the report that goes out contains at least the salient parts of the supporting material. It's bothered me for years. The Melendez-Diaz decision, which was on a cocaine controlled substance case. I was chair of the toxicology section in the academy at that point. I was approached about having the academy do an amicus brief in the Supreme Court hearing at that point, because in all of the documentation that makes up Melendez-Diaz, all there is the one-page cocaine present. That's it, because they stipulated to the result. So all of the supporting documentation of how good or not good that result really was from a scientific standpoint is not part of what the Supreme Court looked at. It's bothered me to this day that the only way really to get that there is if we send out every report with more information associated with it, so that it's always there, even when it goes on through the field. And what you're talking about, just making me think.
Oh, yeah.
I can guarantee, based off of sensitivity, that everybody in here is in possession of cocaine. It's trivial for me to find cocaine on any currency in your pocket. And in fact, years ago we have had, in my research laboratory, we had an instrument that made it really easy to sample basically anything hard. You just basically wag it in there and you can see stuff on it. It's the closest thing to Star Trek out there. Marvelous cocaine sniffer. And I had Prince Abdul Turki, who's the science minister for Saudi Arabia, through the laboratory. And I was told very specifically not to ask him for any cash because it's capital crime to be in possession of controlled substance in Saudi Arabia. So I got one of the people with him to give me a dollar, and sure enough, found cocaine on it. His eyes lit up, and he pulled out this wallet that was the size of a Volkswagen and started pulling out currency from all over the world. And darn if there wasn't cocaine on everything that we wagged through there. So this trace nature of cocaine, if you think about it from a scientific standpoint, and what we're pointing out here in this case is we've got negative, these presumptive cases. We as a laboratory, from the scientific testing, have to be worried about both the type 1 error and the type 2 error, so both the false positive as well as the false negative. So absence of proof does not mean proof of absence. So if we get negatives, we need to continue that testing until we really can't prove a negative. So we keep testing until such point that we just really exhaust all possible testing, or we find the presence of something. So that ends you up with the logical, ridiculous circumstance of everybody in here has cocaine, is in possession of cocaine, because I can find cocaine on any of this currency. But that's the nature of the scientific testing, that I can't prove a negative. So we have as much of a challenge constructing the scientific test to head off the fact that we didn't miss a positive as much as we didn't incorrectly identify something as positive.
And we had talked about earlier, there's policy concerns, and there's not on both sides. There's the lawyers, defense lawyers are pushing you to put broader limits, and
Right.
law enforcement, like DEA, is pushing to put narrower limits.
And we're trying to find the point that
Happy medium.
provides,
Right.
well, not even necessarily a happy medium. Let's face it, whatever result we come up with, at least half the people using our results don't like them.
Right.
So we're trying to produce a result that is scientifically justifiable. That's the goal. And I came here specifically because of the past history of Houston. If we can turn this into something that actually is reliably producing that scientifically reliable result in this circumstance, it can be done anywhere.
Well, if we can, we talked on it briefly. Let's go back to environmental contamination. And we said, there's contamination everywhere. There's probably, you'd probably argue, there's probably some sort of controlled substance in here. be fair to estimate, you know, there's all sorts of pharmaceuticals in the wastewater, and they don't all get filtered out. So, I guess given the wide variety of sources for contamination, obviously the lab has to have some sort of protocol to deal with that. I mean, generally, how does the lab try to avoid contamination within the lab itself?
James can
In
probably.
controlled substance, yeah,
Controlled
we're
substance.
just
James
gonna.
can probably talk best on controlled substance. What I would say is contamination in drugs, like I say, I'm a toxicologist, contamination extends to toxicology as
Right.
well.
Right.
And certainly to DNA. There's a lot of struggles, particularly with and Ron will be here later talking about DNA mixture circumstances, but the potential cross-contamination with DNA. Contamination is a very real thing that needs to get pressed and asked about. I spent most of my research has been, it's always good for a giggle someplace along the way, how drugs get into hair, yeah, I get it. But one of the big challenges is, the doomsday scenario that we pose is somebody has a cocaine party in a hotel room the day before. Do I now look like a cocaine user if I'm testing hair? The answer is probably yeah, because what we've done in some studies is to take a little bit of cocaine, put it on the hands, rub it on hair, and darned if that hair doesn't look like a cocaine user for the next 70 days. It's a real challenge. Uh-oh, what do you do about this? So does the cop say the undercover agent who's in there making the bust at that party, is there enough cocaine in the environment for him to look like he's positive? Maybe yeah. Is there enough cocaine for him to look like he's positive even in his urine or in his blood? Maybe yeah. These guys swim in this stuff. Is the uniform who's there bagging and tagging afterwards, has he got enough contamination afterwards? Maybe yeah. How about the maid that's got to clean up the room later? I don't know. How about the business guy who stays in the room the next day? I don't know. So contamination may be an issue long before it even gets to the laboratory. It may be an issue in the collection of the evidence at the scene. It may be an issue in the handling of the evidence through whatever property room or property handling there is of whatever agencies out there. And then there's also contamination issues within the laboratory that once it's within the laboratory, we have the ability to control for it. But we may already have something that's comes pre-contaminated before we even see it.
Right, because in the lab, we do obviously have quality control procedures that we follow. We
Right.
include those, within our protocols, which is one of the other things that you have every right to see what are our protocols. Ask me for those, I will get them to you. From the lab standpoint as far as the controlled substance section, but also from the center as a whole. We have overriding quality control procedures, and then within each section, we have specific procedures. And that's one of the things that we do everything that we can to monitor and minimize that. And those would be included within the case file to show you what procedures went into place to ensure that that wasn't contamination from within our handling of it. But like the situation that Dr. Stout was talking about, we refer to it as dirty bag syndrome. Those who are dealing drugs, those who are using drugs will often reuse bags. And if I have a case, that small Ziploc bag, it's got some crystalline substance in it, my initial testing may be negative. I can continue to sample and find, well, there's a low level of concentration of a drug in there that I've identified. I can't tell you that's because the bag has been reused. The guy may have bought something
Right.
that was legal, but there was a contamination from its previous use. So like Dr. Stout's saying, by the time we got it, it had cocaine or meth or something in it. But I can only control what happens within the laboratory.
Right.
But that would be something that could be brought out. You could even ask, on the stand, does it happen sometimes that throughout your testing, you have to do a lot of testing to actually make a final identification? Yes, it is. In this particular case, did that happen? Yes, it did. Let's go over all the testing, that was done in that case, And then, again, let the jury or the judge determine the significance to my actually finding the cocaine. But I don't have a problem explaining all the testing that I did and whether the results were positive or negative. And like Dr. Stout was saying, because we have that, I'll call it a double-edged sword, the obligation to identify whether or not there's something present. Again, I'm not determining significance. I know I've repeated that over and over and over again, but if you try and go down that line with your analyst on the stand, you're going to hit a brick wall. Don't ask me what the significance of that finding is, you know, but you can ask me, again, was it at low level? Do you find that frequently? And I agree with what the supervisor told Keith. We find that more often than you would think, and more often than the reports itself would reflect. The report, again, is just a summary of the findings. It'll give you a result, something was identified, what the weight of the substance was. It's not telling you how much of that substance was cocaine. That's where we get into the adulterants and dilutants issue. Within the state of Texas, the weight that I report is the controlled substance, including any adulterants and dilutants present. That's what I'm putting on the report. If you ask me, did you do a quantitative analysis to determine what the percentage of that weight was, my answer will be no. We do not currently have protocols to determine that, but I can give you my opinion. As an analyst who's done a lot of testing in this area, from the results that I have, and a lot of them may be negative, 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 cocaine, cocaine. Yeah. I can tell you from that, in my opinion, it's a low level of concentration of cocaine. The bulk of it is probably not cocaine. I can say that as my opinion, but I can't give you a number. You know, is it possible that it's 1%? Possible. Is it possible that it's 50%? Possible. Again, you're backing me into that corner trying to make me say a number that I can't say. You see what I mean? But one of the things that we are actually looking at is setting up protocols where we could provide that service. Currently, we don't. You know, but that is one of the things that we're looking at because it is becoming more of a concern. And over the last few years, with all of these new drugs that are coming out, you know, the bath salts and the synthetic cannabinoids and synthetic this and synthetic that, we're seeing the quality of the drugs that are on the street is pretty bad. And a lot of times your dealers don't even know what they're dealing, let alone the person who bought it and is using it. They don't know what it is they're actually consuming. And so those lab reports may just not be providing you the information that you need because, you know, you may not have ever seen this substance before either.
Right.
You know? One of the big ones that I like to talk about are the clandestine tablets, the ecstasy. You know, if you get an ecstasy tablet,
Methamphetamine?
exactly. The methamphetamine with caffeine tablets?
Right.
Exactly right. That's what most of those are. So your client may have thought he was purchasing an ecstasy tablet with MDMA in it. I've seen 2 cases of MDMA in the last year. That's actually very rare. But what we see predominantly is methamphetamine. A lot of the cocaine that we see submitted as cocaine is what I mean by that, turns out to actually be methamphetamine. The quality of cocaine samples has steadily decreased since 2009. And now if you see cocaine, more than likely it's of a very poor quality. Methamphetamine, on the other hand, extremely high quality, greater than 90%. And we're seeing it everywhere. It's replacing cocaine, in my opinion. So if you're seeing a lot more methamphetamine, don't be surprised because that's exactly what we're seeing is now being made more widely available. And if it's crushed up, it'll look just like cocaine, you know, in the little Ziploc bags. But when we do our testing, it's going to be methamphetamine. Same thing with those ecstasy tablets. The flip side of those ecstasy tablets is they may be like a fruit salad of all sorts of things that have been mixed together. A lot of times at the end of the pressing of those tablets, when they're being clandestinely manufactured, they'll basically clean out the refrigerator, mix it all together, and press a few thousand tablets. And at that point, it becomes even more of a struggle analytically because some of those I can identify and some of them I can't, again, based upon what the level of concentration is of some of those substances. Yeah. So the point of that, again, that 1-page report is just a summary.
Right.
Really, let's get into the meat of it and say, well, did you find anything else? Yes, I did. Is it low-level concentration? Yes, it is. Yeah. Don't hesitate to reach out to us, I guess is what my take-home would be. Whatever has happened in the past, let's let it stay in the past. I'm available as the manager of the Controlled Substances section, but all of our managers are available. If you have a case, you find the analyst, you want to set up a pretrial with them, you don't have to have a court order for that. That's the other thing that occurred to me. At the time that Keith was requesting these records, we still did require a court order. That's no longer our policy. And that's why we have that statement at the bottom of the report. All you have to do is contact us through our website. And the report has the email address to contact us. It's triage@houstonforensicscience.org, but it's on the report. Shoot us an email, verify that you are the attorney of record for the case, because we need to have that information, and then give us a good contact that we can get back with you, and then we can provide that information to you. Same thing with the pretrial conference. Contact us, help us to ensure you are the attorney of record for that case. We'll set up the pretrial. If you want to meet with the analyst and with one of the supervisors, like myself, not a problem. I'll be happy to meet with you so we can clarify any of these issues, again, before it should get to trial.
Now, if we could kind of go back, we were talking about adulterants and dilutants, and
Okay.
that's particularly problematic in Texas from a defense perspective. But I guess just generally in any sort of forensic topic, you've got this legal definition, and you have trouble interpreting it, right? I mean, at the end of the day, your world is not the legal world, and you're asked to make some sort of conclusion based on this general law that doesn't really tell you, well, this is how you implement it. It's not like a EPA protocol where they tell you to do X, Y, and Z. It's just a general principle. And I would ask, generally, how do you try to interpret those, and how do you set up a policy, and generally, what an overview of your policy on what is an adulterant and dilutant?
Sure. We take the definition as it's written in the Health and Safety Code and apply that as best we can. It's defined as any material that increases the bulk or quantity of a controlled substance, regardless of its effect on that controlled substance. That's extremely broad. How we interpret that is, if I have a container of a substance that I'm testing, I'll determine what the weight is of that entire substance once it's been removed from the container. Then within that substance, if I identify a controlled substance, I'll report that out. So we interpret it to be the weight of the entire substance that is found to contain a controlled substance. And that's where you get into the distinction between the weight versus the quantity or purity. That's what we don't do, is determine how much of that entire weight, including adulterants and dilutants, is actually the controlled substance that you identified.
And I think we'd all agree that it's a problematic definition, especially like, say I took in one of those ecstasy tablets, say it's
Right.
relatively pure, and I threw it into a swimming pool. Is the entire swimming pool now the adulterant and dilutant? It's one of those questions, and you would say there are probably scientists out there that would disagree with something being labeled an adulterant or dilutant.
Yes.
And so, this is one of the things that I think is really important is, and some of the case law supports it, as bad as Seals is a terrible case, but it is a case on constitutionality. It is not on fact question. There's a recent, well, not a recent one, but a Court of Criminal Appeals case talking about bleach and methamphetamine mixture. And it's a sufficiency case. But what it's talking about is the way to resolve it was a battle between experts. And I think that if there's one thing that we need to do in these adulterant and diluents cases, is to request experts. And you've got perfect ammunition under Ex parte Briggs to go up to the court and say, I need an expert in this case, and here is why. There is not a fixed definition of this. This is a fact question for the juries. And I think that it behooves us, especially when it's an issue that ultimately involves interpretation of a law in a scientific field which doesn't relate 100%. There's not a clear connection. You need to have somebody, or at least try to find an alternate explanation as to how this definition should be framed. I guess that's my little soapbox here.
It's all right, we all have our little soapboxes.
Right, and I guess the other thing is, it's really important to realize, we all admit that pool scenario is a problem. And the way that Seals approached the case, it was a facial challenge. And in a facial challenge, it's a very fixed, rigid analysis. And when it's not involving a First Amendment right or a very specific constitutional right, you're out of luck. It's not going to happen. But what they say in that case, and it's pretty clear, is there's an as-applied challenge. And so if you've got a case where it's the pool, where it's the blood, where it's basically the toilet water, that's the time that we need to start objecting and saying, this is not what the law is supposed to mean, and in this particular case, it's unconstitutional. We're not challenging the entire law. They get to say, well, we're gonna cut our cocaine and we're gonna count the whole matter. That's fine. What we're saying specifically is in this particular case, the way they're measuring it is unfair. And I just wanna let everybody know, I looked and I tried to search through all the case law, and I haven't seen a single as-applied challenge. So this is where the rubber meets the road and where we need to start really challenging and pushing things. And I guess another question I had, we talked a lot about trace cases.
Yeah.
In a lot of trace cases, we're talking about charred residue. And I guess in a sense, you could say, well, I detected a controlled substance in there, but in another sense, you could say, well, is there any usable controlled substance? And once again, it's an area where you could have a difference of opinions.
And I think when you talk about charred residue, you're talking about like a crack pipe.
Yes.
Right.
Yes.
And from a scientific standpoint, if that residue that's left inside of the crack pipe has been charred to the extent that there's no longer cocaine present, then I wouldn't report cocaine.
Right.
You know, so that's why I just want to clarify, again, one of the differences scientifically, maybe the cocaine was smoked, but it's that residue on the inside. And I also need to make a clarification. If you get a lab report that comes back and says trace on it, we don't always report a weight. So that's why I try to make the distinction between what I as a scientist would call trace and what I would call low-level concentration. And it's based on that weight. The crack pipe scenario, I would report that as a trace. And the way that we look at it is, if there's a substance present that I cannot easily remove from the container, you know, like turn it upside down and dump it out, then I would call that a residue amount or trace amount. That's what that report means. It's something that's stuck to its container that isn't readily removed to obtain a weight. It doesn't mean that it's a small amount. The analogy that I use is a measuring cup that you're using to make a cake. You measure a cup of flour, you pour the flour in the mixing bowl, what's left inside the measuring cup? A residue of flour. As a scientist, can I detect flour? Of course I can. Can I determine a weight? I can dump it out on top of my balance all day long. Nothing's coming out to weigh, so I would report that as a trace. You see my point?
Right.
But meanwhile, if there is a small amount of flour left inside that measuring cup and I can dump it out and weigh it, that's what goes on the report. Let's talk about what's in the mixing bowl. All right, you've added the flour, you've added the sugar, you've added the cake mix, you've added all of the ingredients. I can still detect flour in that mixing bowl.
Right.
What weight am I going to report now? The entire contents of the mixing bowl, because if you're looking for flour, everything else would be adulterants and dilutants. So, and as an analyst, I can explain that. And that may be significant. And I think I totally got away from your point.
No, I mean,
No, the chart. Sorry.
I think this is all part of the point. I mean, people need to understand, and everybody, you know, we all need to understand what everybody's thinking, what's going through everybody's mind, in order to say, okay, well, this is how we need to approach these cases.
Yeah.
Because I think too often, you know, as a defense lawyer, you would assume that, oh, this is a result, I can't dispute this, when the thing is, well, these definitions are hazy, they're fuzzy, and there's not a lot of clarity.
Yeah. When you say this, what do you mean? We often don't get that opportunity to explain what we mean when we say something, or when I look at your report, what does it mean? You know, it's just kind of taken for granted, you know,
Right.
And that's where we are all falling short, I think, you know, is going into that detail and finding the meaning behind the report and the testing and the results.
Right. And I think when we met one of the times, we talked about one of the other things that I find is problematic is a lot of times you can have a substance that absorbs water. You know, you could have a pill and it can absorb moisture. And, you know, a lot of times just because it weighs X amount, there's an uncertainty in that, and and there's a question of who added it, when it got added. I mean, these are not easily resolved questions. And once again, your role is to tell, this is what I observed, this is what we tested, these are what but once again, we're not talking about, well, this is what happened, and these are the processes that happened, here's why it weighs that. There's a lot of these steps that are problematic in this process.
Right. Crack cocaine, perfect example. Depending upon what point you are in the manufacturing process, it can be very heavily wet,
Right.
or it can be very dry. And we find that a lot of times, even especially coming out of that toilet bowl. If they throw a bag of crack cocaine in that toilet bowl, the officer pulls it out, it's gonna be wet. And that's how we're going to weigh it when we receive it.
Right.
Now, if it's really, really wet, we're gonna dry it out first. But if it's just the crack cocaine that retains a lot of moisture, we're including that water weight. But we're gonna make a note in our case file that says, you know, wet,
Right.
damp, et cetera, when received. And that could be a point that you would want us to bring out in the line of questioning. You know, but again, on the stand, we can't volunteer that information. We have to be asked that information, yeah? And you might wanna know that before you get to trial.
Just as an aside on that, if you have a case where these issues come up, there is a lot of information available online. First, read the 2009 DOJ report regarding forensic sciences, if you haven't, because it's illuminating. There's just a lot of things that you may take for granted that aren't necessarily so. It's 6 years past, things are getting better, but still. The website that, I still say HPD Lab, but now it's, what is your official title?
Houston Forensic Science Center.
Houston Forensic Science Center, very good, a lot of the protocols and whatnot, and read up, because if you go in there, if you don't ask the right questions, you're not gonna get the answers. You need to read up and know what their thing is. I mean, understand, they're looking at it from a scientific point of view, plus or minus. Is it positive or is it not? Part of it is because, I mean, this is from my opinion, they're going for what is their end user. Their end user is law enforcement. They want to know, is it a controlled substance or is it not? That's why they're not going to really talk about the quality of the dope. They're going to go, contains cocaine. That's what they need for the law. Okay? That's what the Court of Criminal Appeals has said, that is legally sufficient for your case. Now, whether the science has changed and whether the machinery and everything is now so sensitive that, you know, your dollar bills, you're all possessing cocaine. I'll be happy to take your dollar bills, by the way, so none of you will get busted for possession now that you intentionally know. But, I mean, that's kind of where the law maybe hasn't caught up with the science, or the science hasn't caught up with the law. But the other thing is, even though they are now the Forensic Science Center and everything, as a defense attorney, and this is my opinion only, you still need to be cognizant of what their end user is, and a lot of the analysts, and I think as you go up their food chain, you get a more unbiased factor as far as, but for instance, the analyst that testified in my case would not even acknowledge that there was such a thing as contamination. So let that sink in a little bit. And then to go to his point as far as maybe you do need an expert. In my case, I thought I had enough reasonable doubt, and I thought I could show the bias of the analyst. And I think I did. But it's something to think about.
And I think the takeaway point is the Court of Appeals is not gonna come and save you in any of these cases. I mean, these are very much trial cases. I don't see where they're gonna come in, so, you know, it's all about having the information, being able to assess it and have a clear strategy. What was I going to ask? There was something. Well, I guess this would be a good time to open it up for questions.
That's a great question, Clint. As far as the evidence itself goes, physically viewing the evidence, you still have to go through HPD because it's in their custody. The process now is that we get the evidence from HPD, we test it, and we return it to HPD. So you can contact us to get copies of our records and to set up a pretrial conference. To view the evidence, you still have to go through the HPD property room. as far as our lab reports go, the only time that we would use a footnote or a notation that says visually estimated to be less than a certain percentage would be on a marijuana case that has something else in it. So otherwise, it would have come from a different lab.
I would be interested
You
in
would
seeing
have,
those.
yeah, I would need to see that.
I would be very interested in seeing those. Now, if you've got some, I mean, I'll give you my card, I'd like to see those. Yeah, I'd like to see that.
And we'll wait, if you truly have one, I will wait
Yeah.
until we can get it. We're being very sincere. I need to see that to make sure that I'm not misspeaking.
The email blast, you'll have your email addresses.
Okay.
Maybe you can send it over.
So when we, Colin, we need you, talk about your lab results, you'll walk us through your case file, if we ask, and your time limit, how easy is it? I think you're gonna do a lot.
We'll work through it. Let's see where it goes.
Will you shoot us the stuff in email form?
Sometimes the information is a little too large to email, to make it on a DVD. Again, something to work through. Like I say, I would love to be in the position that we can get this stuff all glued together, goes as the report all together. The legacy computer systems that we are working on fixing, shall we say, is going to take a little time to get that fixed. Cause it is, you try and think how we create reports for the, 25 to 30,000 requests we get a year. If we're gonna do that across everything, how we do that so that, your drug result doesn't end up being on your DNA report. We gotta work through that. But in the interim, ask us, we'll deal with the volume as we deal with the volume, and we'll work through that.
And along the same lines, when we had, so after we talked to you, we have a trial case and we're gonna have to, when we had you on stand. We asked you a question and you'll explain like the flower scenario. You'll explain, tell us on that scenario. You'll explain that.
Oh, yes, ma'am.
Okay.
Yeah.
Are there any, local labs, while you get your own expert, are there any local labs in Houston that are accredited by DCF to do DNA and blood tests?
My understanding is no.
I can tell you I found one in Arlington
Right.
that does, drug tests.
And it,
You haven't had those double done, but it doesn't mean they're ever gonna find anywhere.
That's on the website, right?
it's,
Accreditation.
I believe so, yes, they've got it, but, I mean, it's a real problem, and unfortunately, but that's a money problem, and that's a court's problem, and they're the ones, and I think all you can do as a lawyer is preserve and explain why it's important, and come in here and say, this is a trace case, or this is a case involving a very, very low amount, and I need someone to come in and explain this is not an adulterant or dilutant, and put them on the hook. You request the expert, you file the AKI motion, you go from there.
And the problem is, if you get an expert in like Pennsylvania, it costs a lot of money to get that expert down here to testify, and the courts don't wanna pay it.
Well, I think one of the things the courts are, the higher courts are becoming less sympathetic about are the refusal to pay these experts. If you can show how it's important, and you have enough knowledge to say this is a very small amount in this case, I think that's where it behooves you to. And as long as you can make a good basis, that would give somebody, that's a legitimate issue to appeal.
Anything else? All right. Thank you, gentlemen. Dr. Stout, James Miller. Next one second to set up, your ethics hour is coming up. So take out 3 minutes.
I thought it was Bill.